People deemed unlettered could fall prey to fraudulent schemes of others in situations where documents are to be executed, signed, or relied on. Ghana's Illiterates Protection Act and its amendments, as part of the broader legal sphere, seeks to curb such incidents. Stay with us as we discuss the Illiterates Protection legal regime. My name is Noella Seidu, and you're welcome to Law Express.
Kofi Ampiao is a private legal practitioner who enjoys movies, reading, and soccer in his spare time. Nana Boachi Mensa Bonsu, a private legal practitioner who loves to play video games and watch movies in his free time.
Noella Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
So today, we need to understand who an illiterate is for the purposes of this discussion. Mm-hmm. Now, under the Ghanaian law, an illiterate is anybody who does not understand or cannot read any information or document written in a particular language. So that's to say that if you can read and write in English, and you are presented a document which is written in, say, French, Arabic,
Dabanli.
Yes, or Twi, which you cannot understand or read, then you are an illiterate for that context.
It's very important to say to clarify this, because many people, when they hear illiterate, they just think about English. Especially in our Anglophone setting.
Yeah.
Because you're thinking formal British colonial educational system and not the other aspects of it. So if there is a Twi Bible and I can't read it, I'm an illiterate.
Yeah, for that purpose.
All intents and purposes in respect of that arrangement.
Yeah.
And it's the same way that somebody else who can read the Gari, write the Gari, but who is faced with probably a Fanti document is an illiterate in Fanti.
Yes. Yeah.
So it means that irrespective of your level of education, you could still be illiterate in respect of a document you've executed in a language which you do not understand. So we shouldn't just limit illiteracy here to someone's level of education or the level of degree or degrees the person has. Just that in the context of the law we are looking at, it reaches out onto the document you've executed and the language in the document. Do you really understand what was in there at the time it was executed? Yeah. That is what discussion is about.
So clearly, in context, illiteracy in law is more or less what we would describe as a term of art. It's not what most people understand illiteracy to be. And to protect the illiterates in law, we have a very old law which dates back to the 90s, the early 1900s, which seeks to protect the illiterates in law. And historically, why this law came to force was simply because the natives were not knowledgeable in English and other European language, which were then the trading languages in Ghana.
So to add to that, this is clearly a hand-me-down from colonialism.
Yeah.
So this law was mostly a British law to regulate, how, or colonial law, let me put it that way, to regulate how people deal with documents written primarily in English.
Yes. And the interesting thing about it is that if you look at the history of the law, you realize that even for the British themselves, illiteracy is no defense.
Yeah.
But then they realized that during the times that we were in, a lot of the natives were clearly not educated. So there was a need to protect them in terms of documents that were executed. There are cases of native chiefs signing certain documents with even the British nationals themselves that they were trying to enforce against the chiefs. But they realized that no, looking at the level of understanding when it comes to English, there was a need to shield these persons. So hence, even though illiteracy is not a protection in the British regime, under Ghana, they decided to protect us based on the level of education.
I find it difficult going with this rationale about protection. I would not say that was the primary purpose of the law.
No.
But I would say is that at the time, I do not believe that most of the natives, people of the Gold Coast, were actually writing.
No, they weren't writing.
You could speak a lot of languages, but were you able to write that down? Were we really that sophisticated in putting down our materials, our information? We were using witnesses and all of that. So this was a colonial way to bring in the importance of documentation, one, and also to place people in there to see every document that is written, such that, of course, you need to, it's about English language, right? Because that's what's being broken down on paper. So those people who are now regulated by the British authorities would have to come for licensing, and by extension, they are able to pass on any contract that has been signed.
Well, I mean, that's very valid, because if you look at it within the context of when the law came up and all of that, there were more Africans entering trade relationships with the British. So
yeah,
to get whatever that was done, or get whatever trade you were doing down
probably
on paper,
to protect their interests
to protect
more.
their interests more, there was a need for this. And so they created some form of licensing system to regulate those people who were described then as letter writers.
Mm-hmm.
And these letter writers were then required to obtain a license so that natives could go to them to draft their contracts and letters for them. So if you look at the law, it says letter and any document.
Yeah.
Any document is wide. The definition of document has been said to be very wide. So contracts, wills, and all of that fall under it. Receipts fall under it. So essentially, that was what it was. But then we need to look at the nature of the license. It was an annual license. And when you take the license annually, it means that you, as the letter writer, at the end of the year, you need to go back to the colonial government for some licenses.
Before we go to this whole licensing or regulation of letter writers, let's rewind to prohibition of letter writing for reward. So that aspect of the law does not stop you from receiving reward for writing. It just wants to regularize that whole activity.
Yeah.
Yes, obviously.
It's like you're providing legal services for reward. So in this particular instance, if you want to show that you're educated, you would of course have to meet certain standards, right?
Of course.
Qualifications to first be licensed.
Yes.
And then when you're licensed by the local authorities, that is the assemblies, you'll be given some kind of certification. Then you can now present yourself out there to give your services to people. But in all of in this whole arrangement, there is this conversation of when the certification expires. So it doesn't matter when you get it; it ends 31st December
of each year.
Yeah, so it's wiser to have it 1st January than to probably have it on the 20th of December, because you would have just 11 days before you have to renew it again.
Yeah.
Yes.
Yeah, that's true. That's true. Taking it from the point of the prohibition to the licensing. Now, the essence of the licensing was also to ensure that those people who are writing the letters are actually performing certain obligations to the people who come to, that's their clients.
Some standards.
Some standard. They have to meet some professional standard. So the law itself provides some of these professional standards and obligations which they had to meet. So I think we should have a look at those also because I mean for the essence of the law falls within those professional standards. Yeah. If you were to write for anyone under the law, you are required to explain what you are writing to the person or to the illiterates. Yeah.
Okay, so maybe let's simplify it by talking about reading it clearly and correctly.
to the person.
You ought to also provide what we call an attestation, or technically we call a jurat, showing your name, your address, and also showing that you have clearly read over and explained the contents to the illiterate person before they made their signature, if they have it, or any mark at the bottom of the document to show that they've understood whatever they've executed in that regard. So this means that when an illiterate executes a document, there has to be a person or either another person's direction calling on someone to read clearly and explain the contents to the illiterate. Then when that is done, there has to be an attestation, or what in law we call a jurat, for the illiterate to make a mark, which has to show that everything in there has been explained to him. He understood it before he made his mark at the bottom of the document.
So, talking about the understanding of the illiterate, we need to ask ourselves, what language should the writer or the person communicating to the illiterate use? Now, it shouldn't be necessarily the native language of this illiterate. So, for instance, if the document is written in English and the person you are explaining it to understands Twi, the person may be an Ewe man and speaks Ewe, but if he understands Twi and speaks Twi and you're explaining Twi to him and he appreciates what you are saying, you have fulfilled your obligations under the law. So it's simply about any language the person understands. So you translate whatever you've written clearly to the person. The rationale is this. Perhaps the person came to you seeking for you to sell or to draft an agreement selling or leasing a parcel of land for 50 years. And now, in giving you the instructions, you ended up writing that the land is going to be leased for 70 years. In explaining what you've written in English to the person, in the language the person understands, the person may realize his error and actually tell you that, oh, I meant 50 years. So can we correct this?
You know, this is not even limited to different languages and illiterate people.
Yeah.
Even when you draft a document for somebody else's benefit, for instance, people have an understanding and you are to reduce it in writing, you need to explain it and let the person understand and be sure that it aligns with what they intended.
Of course.
So in this case, the main thing that sticks out is the fact that there's a language problem.
Yes.
And so based on that, it doesn't even matter how proficient the person is in the language that you're explaining it in, for as long as they can appreciate the subject matter, the intention, and have a clear understanding of all the terms.
Of course.
So you break it down. Once the person writes it down, either for reward or for free or whatever to assist, first it should be clearly and correctly. So it must be clear, it must be correct, and it must be read out by the writer to the person who is to benefit from this document, or on whose behalf this document was drafted, and you now explain. So apart from reading clearly and correctly, you need to explain it to the person in a language the person understands. Then after that, once you've satisfied that threshold, they make their mark.
Yeah.
Mm-hmm.
But you also, as the one who drafted this document or wrote it, have to put your mark there on that same document to show that you were the one who did this job.
Yes.
Because you are a professional who has been licensed for this purpose. And then the next thing is to indicate how much you collected.
Yes.
Yes.
I was once in court when it came up, and a judge looked at the law and said that the law requires that not only does the station clause should end it, but then you also have to state the reward based upon which that explanation was done. I think on this tangent, we can now look at the issue of the attestation and the mark. Looking at the law strictly, it means that there has to be a jurat. If the jurat is not there, then the position is that whichever explanation or the document before the person was not explained to him in a language he understands. However, our courts have evolved a bit. So the position now is that even where there is a jurat, in order to protect the illiterate person, it will not be taken stricto sensu that the person understood the language in which it was read and explained to him, which means you have to lead evidence of certain surrounding circumstances. Oh, he came with his wife, for instance. His wife is literate in that language. So even when I explained, the wife even went further to explain to him. So he understood it. So the presence of a jurat or the attestation we spoke about does not necessarily mean the person understood it. You'd have to lead evidence to show otherwise. Now, if you look at another angle of it, one would also say that then once a person executes a document and there is no jurat, the person will claim that I'm not literate in that language, so I don't understand it.
Oh, I've seen it happen where somebody said he couldn't. So there was a whole trial. He said he didn't require an interpreter. So he was testifying in English. Something happened, the trial had to be started de novo, meaning it had to be started from all over again. And all of a sudden he says he only speaks Fanti and he needed an interpreter.
Yeah, but I mean, the aim of the law is not to enable this person avoid liability. I mean, that's if you are caught up by your contract, you cannot avoid it simply because you claim there was no jurat or that because there was no jurat, it wasn't explained to you.
It's enough to show that, I mean, if you can prove that you didn't understand.
If you didn't understand, you can prove the
document. How can you execute something you didn't understand?
If you can prove that you didn't understand the document, then yes, that is to your advantage. But where, because there's no jurat, you simply say, oh, because there's no jurat, it wasn't explained to me, that will not stand. Because the other party can still show that the document was explained to you. My brother here explained that the circumstance become relevant. So if the person is able to establish that it was explained to you, this was your understanding, these people were around, and if let's say Kwame was around when it was explained to you, Kwame comes in to say that yes, it was explained to you, and this was your reaction. You even ask questions. Then, despite the absence of the jurat, you still be liable for whatever is written therein, and you cannot escape it. Now, most people will try to use that to their advantage. Unfortunately, we cannot have everybody in this world being either honest or genuine in their dealings with people. So somebody who might have had the advantage of having the document explained to him or her, when faced with a difficulty, will quickly jump to the fact that, oh, it wasn't explained to me. I didn't even understand English.
The advantage about the law and how it is couched is that this document, okay, is drafted for the benefit of the illiterate.
Yeah.
So it limits or lowers the chances of the person drafting it going against the one who is giving him the job, because you are paying for the service.
Yeah.
And so you are working in the interest of the illiterate. You would notice that when the Illiterates Protection Act does not talk about documents that are brought to enforce against the illiterate where they were drafted by somebody else. But before we make those incursions, let's go for a quick commercial break. Stay tuned, this is Law Express.
Just before we went on the short break, you mentioned the fact that what happens if the letter is commissioned by some other person and not the illiterate. So the standard is the same. The courts in Ghana have said the standard is the same. So if, say, there's somebody called Adam who is the illiterate, and Kofi here is the literate, and Kofi prepares the document and presents to Adam for execution, there's an obligation on Kofi and whoever he comes with who prepared the document to explain to Adum the contents of the document so that Adum appreciates and understands what he's getting himself into. Now, if Kofi and the person he comes with who created the document, who drafted the document, fails to do that, they breach the law, and the illiterate, the court may, should this matter eventually end up in court, the court may find that because the person did not appreciate what he was doing, he is not liable for it.
So it's the same standard?
It's the same standard.
Only difference is that in this situation, it's not the illiterate who is paying for the service.
Exactly.
It is the other person who is paying for the service.
Exactly.
Yes. So moving on into the legal profession scope of things, for lawyers there's a high standard on us to ensure that documents we execute for our clients are read over in a language they understand, explained, and they truly, truly appreciate it before making their mark, that be either a thumbprint or a signature or any other initial to confirm that this document has been read over and explained to them. This is essentially important because if you look at the law, where a document is prepared by a salaried clerk or a lawyer for an illiterate, the law presumes that the illiterate understood the document before he made his mark and he signed. This is the case because you are a lawyer. You are presumed to have a fiduciary relationship with your client who is an illiterate. So before you commit your client to any obligation to any third party, you would ensure that your client truly and truly appreciated before appending their signature. So for lawyers, we are also caught in this same legal space, and the bar is high for us because it creates an exception against anybody seeking to enforce such an obligation against our clients.
But you look at it, and when you just oppose it against the letter writer within the meaning of the Illiterates Protection Act, that person's main job is just letters. Now bring it to lawyers, and you have a lot of gamut of other things you do. But it doesn't take away the fact that as part of your responsibilities drafting documents for reward, just like the letter writer, you also are licensed, but from a different setup and not from the assembly like the letter writer. But at the end of the day, you are as bound to these proceedings, the conditions, okay, for persons writing letters for illiterates, because the conditions do not talk about certified by the assembly. It just says persons writing letters for illiterates. So the whole thing, intention of the law is to remove busybodies from busily typing letters for others without the benefit of the law. And that is why the regulation is in place. So it recognizes clerks who are salaried for the purpose. So these are secretaries in offices and all of that. It recognizes lawyers who may charge for it, and the understanding is that you would know the law, you are learned after all, and you would know what conditions to follow. And then, of course, those licensed by the assembly. Anybody else, it becomes, you are not allowed to do that for reward especially.
Anybody else, you can't actually do it for reward, you just have to do it gratuitously.
And at the risk.
And at the same risk. But I mean, just to emphasize the fact that for us lawyers, because the standard is high and because we are licensed to provide that particular professional service, it's always best for the person or the illiterate to go to a lawyer for the execution of his documents. I mean, the truth is this. With a lawyer, if he prepares the document for you and you execute it without your understanding, you have recourse against him professionally, because he's professionally liable to you. So you can sue him and get a remedy, not protecting your interests, because he breached his duty to you. So I will always advocate. I always tell my people, it's safer. Go to a lawyer, let him prepare the document for you. If you don't appreciate the language it's prepared in, or you don't even understand what you asked for, let him break it down for you in simple terms so that you get an understanding and you know what you're getting yourself into.
Let's look at witnesses. So after you've made your mark, most contracts require witnesses.
Yeah, that is so.
And especially where you have an illiterate person, it's safer to have that witness, right? The law provides that these witnesses are not also supposed to charge a separate fee after the letter writer has charged that fee. So your lawyer has charged a fee, then your witness too wants to charge a fee, or the professionally licensed letter writer, once he charges a fee, another witness or any witness to this document can also ask for more. So that people don't make this a whole profession where you make yourself the professional witness
and cash out,
sitting around the letter writers and lawyers' offices to keep witnessing things for people
and cashing out of it. But I mean, the good aspect of this is that with the provision of witnesses, even when there's no jurat, those witnesses can actually tell you that can actually tell the courts or whoever, any tribunal, that the document was explained to the illiterates. And that's a good aspect, because the obligation to show that it was explained to the illiterate is either on the professional or the writer.
Let's look at the penalties. So there's criminal liability.
Yes, there is.
Or should I say there is some imprisonment, custodial, implication for violating this act. It might sound so simple, like, what is wrong if I just draft a letter and collect money?
Yes.
But there's more to it.
So if you look at the legal regime here, what I believe the law on the penalty is trying to do is that since we are seeking to protect a person who may have executed a document in a language he doesn't understand, then we should ensure that only the right people end up drafting these documents for them. Mm-hmm. And only the right people also end up explaining in the language they will understand for them. So in this regard, the law says that if you are not licensed, or even if as at the 31st, your license
has expired,
and you go ahead to draft a document for a reward, especially, then you should and you don't have a license, then it means that per the law, you will face a penalty point of 50 units.
That is upon conviction.
That's upon conviction.
So let's come in here before you now tell them how long they will stay in jail or be fined for. It only becomes a problem on your court, okay? Because if everything goes smoothly after you wrote that contract and everybody played their role, you have no issue. You may survive this and keep making your money. The challenge is where the situation fails, and now somebody is, losing as a result of your, what should I call it, your foolhardiness.
Or and then busybody.
Being a busybody. It's not a busybody, you're trying to survive here. You were just stubborn. So based on your conduct, then you'll be liable. So you can now tell our viewers.
Yes, and if you look at even the Legal Professional Act, mm-hmm. Act 32, if you read it stricto sensu, my brother here talked about the fact that it is always safe for you to go and see a lawyer in executing any document. And if you even juxtapose that law with the law we are dealing here with, you realize that it is even an offense for any person to draft any document for any other person if the person is not a lawyer. But the law here creates an exception for a person who is licensed.
You have to look at the time this year first came into being, 1912.
Yes.
How many lawyers were here? And how many people could afford the services of lawyers?
Yes, and so that's what I'm trying to say, that since both of them are acts in themselves, then this Illiterates Protection Act will create an exception for persons who are not lawyers, but have to have a license.
But that will depend even on the kind of document. For instance, if you're drafting a conveyance, you must be a lawyer.
Yes.
Obviously.
So there are some documents that you must be a lawyer for, but then it's considering other things.
Like simple letters.
Maybe even a will.
Yeah.
Okay, you're looking at,
Yes, that's another interesting topic you brought, because if you look at the Legal Profession Act, then the only document a non-lawyer is allowed to draft for a person is actually a will. But however, the problem is that even of the will, there has to be an attestation clause.
You know what? Let's hold it here. Hold your fire. We will pick up from right here, because it's very, very important that we clarify these issues. But we sampled people's opinion on the streets of Accra. Let's take a listen. We react to that and continue with our conversation.
Illiterates are not well protected enough when it comes to signing of documents or contracts, because when we talk about illiterates, we know that these are people who can write or read, and so if they don't understand what is in the document, how then do they sign? And so I think they are not protected enough, and so they should be able to explain the details of the document or the details in the contract to these illiterates to understand it better in their dialect before they sign.
I'm not an illiterate, but with my little experience towards illiterate protection in regards to Ghana law it's kind of bad because of my experience. 4 years back, I had an accident at La Paz and I was taken to the hospital. Later on, we follow up by lodging a complaint at the Tesano police station where the driver's car was seized because he was then at fault. The traffic light was red when he hit me. And later on, we realized that the car has been given to him without our authorization. Then my parents weren't really active because there were some little family issue. But at the end of the case, we weren't given justice. I was not well taken care of, and my parents have to take care of all the bills. If I had a lawyer to actually take the issue again, I would have looked further into this because I wasn't treated fairly in regards to illiterate protection in Ghana.
Well, I believe illiterates ought to be protected when signing documents because illiterates are mostly not knowledgeably inclined about fields of study. So for instance, if you are signing a document, say tenancy review, and then you are an illiterate and you are not guided as to the terms and conditions that come with it, the legal aspects of it, we tend to undermine them, we tend to marginalize them, we tend to take use of them, taking advantage of them. So I feel illiterates ought to be given the necessary understanding, ought to be educated as to the do's and don'ts, the kind of regulations that comes with it. So I feel they should be protected whilst they are being educated as to the negative and positive implications that comes with whatever they are signing.
When it comes to contract or signing a bond, it goes with rules and regulations. So even those people who are educated need lawyers. And if somebody is not educated and must be explained to him, it should be explained to that person's understanding, so that when there are any consequences, that person will face it. But the situation where we give a document to somebody, the fellow signs it without understanding it, it will be pure injustice to hold that person responsible, especially if they are illiterate.
One of the gentlemen talked about when people go to various state institutions like hospitals and others, they just end up signing documents without it being explained to them. I mean, that's one aspect which we have to look at critically, because at hospitals, banks, and other institutions, various persons enter the institution. They may not understand or appreciate what they are signing, but they end up signing it, and it comes with a lot of responsibilities and liabilities. I'm dealing with a situation where a gentleman had signed up to a loan, and for all intents and purposes, he can't read, but he signed the loan agreement at the bank, and now the bank is chasing him for the money. Did
he spend the money though?
Well, he did spend the money. But
so did you think the bank was Santa?
No, but he did not appreciate.
You walked into the bank for a loan. The bank gives you the loan.
Agreement. He signed.
You spent the money, and you didn't even ask, how do I
long
pay back?
Yeah. Yes, but he didn't appreciate the full extent of the agreement. I mean, so it really goes to the fact that, in as much as we are advocating for lawyers and other people to explain the documents they are drafting or commissioning for these persons who are described as illiterates, there's an obligation on these institutions, established institutions, banks, hospitals, among others, to get individuals who may be able to explain the content of their instruments or documents. I totally
agree. It's actually even in the interest of the other side. So you might think you are the bank and you are the stronger side, but it's in your own interest to ensure that this person understands the document, and there's evidence to support the fact that it was read to him and explained to avoid situations like this.
Yeah, that is true. Now, another lady spoke about the fact that she's not an illiterate and went on to comment on some experience she had at Tesano police station or so involving an accident. So if you look at the context in which we are having this discussion, the literacy here or illiteracy here deals with the fact that you've executed a document, or a document might be enforced against you, and at the time that you may have executed a document, the language in which it was written, you cannot read and write within that language, and clearly it was not also explained correctly to you for you to appreciate what you were signing. So she may be literate in the sense that she's gone to school and probably might even have a master's. But if, for instance, she had gone and executed a document in Flemish, the law will see her to be illiterate in Flemish, and that there ought to be someone who would have explained to her, either maybe in Twi or in English, to understand. And maybe there will be a juror to saying that this person so and so has read over the document to her, right? So the illiteracy here is not really about the fact that you've gone to school. It's about the fact that you might have executed a document in a language which you cannot read and write.
Once you brought up her experience on Law Express, I mean, we're not going to just disregard it. We've had previous episodes where we discussed insurance,
yes,
and road traffic offenses. Yes. So if she is able to watch those episodes, she will be able to understand at what point she can talk to a lawyer. I don't know how long ago that was, but there's a fund that takes care of people who are hit by vehicles that ran away. I mean, the law provides a cover for all these people, so she should probably check our YouTube channel to look through our previous episodes on road insurance and road traffic offenses, stuff like that. She's going to find material that will help her probably get some compensation to cover up for the expenses she may have incurred as a result of that accident. But there is a disconnect generally listening to people's opinion on this, at least from the sample population that we have. It's the mistaken belief that illiteracy is about speaking English. I understand that it's an Anglophone space. We instruct in formal education in English primarily. Recently, there were inroads being made to instruct in English and other local languages. Yeah. But our local language instruction is limited to just learning to write the language, such that you learn probably at the BEC level to just pass, and after that, unless you are going higher to probably study Twi, Ga, Ewe, Dagari in the university as a languages measure, then you might not have to deal with the local language again, unless in the casual spaces where you probably go to church, and maybe the church, they preach in Twi and they have Twi Bibles. You could get the benefit of learning to read Twi and you become a literate in Twi. So illiteracy is not about sitting in a class and getting a certificate. Within the context we speak to today, it's about being able to read and write a particular language. So you probably may never have been in a class. You probably may never have even been taught by another person. But if you can self-teach yourself, you can self-teach the language to read and understand it to a level that makes you a literate, then you are. Now people use Duolingo and other apps to learn other languages.
Yeah.
I was trying to learn French. I don't know what to say about my progress, but if I make it and I can read and write French, then I'm literate. Until then, I'm an illiterate.
Yes.
Because beyond the greetings, most of us are just stuck.
I'm tempted to ask how long you have been on it, but...
I know you know what's going on, Nana Boachi, and I would not take this bait. I won't bite. So it's beyond English. Can we now go back to the liability for offenders? Because you did not mention the term of imprisonments and the fines. You were about to enter it when I interrupted, so please.
Okay, so basically, if you are convicted for preparing a document for reward for an illiterate without a license, the law says that you may be sentenced to 50 penalty units, and one penalty unit is 12 cedis. So you have to multiply 12 cedis by 50.
Yeah, lawyers and maths. I know you wouldn't attempt it.
I will not even try it. Are we talking about 600 cedis?
That's about 720 Ghana cedis.
Yes.
I pray to God you guys are right.
Or
that's the fine.
1 month imprisonment, not more than 1 month.
Not more than, So it could be between 1 day to 1 month.
Yes.
Yeah.
But if you are caught for a subsequent offense and you are convicted on it.
Repeat offenders.
Then you could be sanctioned of 150 penalty units.
So times
3. Or for a term of imprisonment, not more than 3 months. So between 1 and maybe 90 days.
Yeah.
So it is very essential that before you put on the obligation to prepare a document for an illiterate,
draftsman, Self-styled.
You ensure that you have a license and you go to the district assemblies and you inquire the process based upon which you will get this license. Because you may think it's simple. You are helping your auntie out or your friend out who probably may have not gone to school or anything, or doesn't even understand that language, but may have gone to school.
Yeah.
You should make sure that you have a license before you carry on such an obligation.
Well, I mean, I think that the essence of the penalty is to give whoever suffers some wrong as a result of not understanding the document which he signed or
some justice, huh?
Yeah, some justice. So, I mean, the reality is that you may either seek a civil remedy or you may report the person
to
the police for criminal proceedings.
You take the person to court.
You take the person to court, yes.
Yeah.
You may take the person to court and have some damages awarded in your favor or some...
Because the fines go to the state.
The fines go to the state, yes. But if you want to report the person to police, then that was what will lead to the criminal prosecution and the fine. But I mean, I will always advocate for the civil remedy, because then at least that will come to you. The compensation will come to you. Yeah.
We'll go for a quick break. When we come back, we take up the discussion a little more in terms of the summary nature of the proceedings regarding drafting for reward without the requisite certification. And then we will try to answer some questions coming in by way of social media.
Okay.
Stay tuned. Still Law Express.
So where a person has been brought to the court, the law says that the procedure there will be done summarily before the district court. So generally, we have trials, summary trials, and we have indictable trials. Indictable trials are for very serious offenses like murder and sometimes robbery and other offenses. But the summary trials generally are what most common offenses are prosecuted under. So basically, you have a judge, you don't have a jury. The judge itself is a trier of the facts and the evidence, which means the judge sitting at the district court will take all the facts surrounding the case and the evidence and reach a conclusion, which means the prosecution will present their case, they'll present their witnesses, they'll present their evidence to establish a prima facie case that you prepared a document for an illiterate and took a reward, but you did not have a license. Or even if you had a license, by the 31st of the previous year, it had expired. Now, since it's a summary trial, should in case the district court hold that you have a case to answer, you, the person being accused of preparing a document for an illiterate for a reward over a license, will also call your witnesses, bring out your evidence to establish that you have not breached the law, or you may have even had a license.
Okay.
When that is done, the judge will now sit down, conclude, looking at the facts and the evidence, and come to a conclusion whether he should be convicted, and the penalty units or the custodial sentences we spoke about earlier on should apply.
Finally.
So basically.
So I mean, I think what my brother is simply trying to say that
in simple
terms, the offense under this law is considered to be a minor or small offense. So they will take you to the district court.
So let's start from where the complainant reports to the police.
Yeah.
So it's the police that is the prosecution, like you said.
Yes.
So the police now comes in to prosecute the matter before the district court magistrate. Okay.
Yeah. So the police would simply go through the procedure, which is the simplest criminal procedure we have in our country, because the aim is for it to be fast, and as most people say in our local dialect, partial. So it goes quickly, and within about a month or two, partial. About a month or two, the proceedings are over, and you know your fate, whether you are going to end up in prison for a month or you are paying a fine, or whether or more,
or 3 months,
or
3
months
or more.
That's if you are a repeat offender.
So I mean, the fastest and simplest way of prosecuting is what will be used for this.
Great. We have some questions that have come in by social media. Let's try to resolve them, considering that we do not have the benefit of follow-up questions from these people?
I dropped out of school in class 1, yet I can speak decent English. I can, however, not read or write. I was given a job a few months ago and asked to sign on some dotted lines. I do not write, so I asked to thumbprint the portion. I want to leave my job, as my employer keeps changing the terms of the contract as we negotiated. She keeps saying that her opinion of our agreement is what we signed, but that is very different from what we discussed. What can I do?
The person doesn't indicate that what she signed was read to him or her, which is the first problem we have here.
Yeah.
The document, that's essentially an employment contract from what I heard, should have been explained and read to the person for the person to appreciate and understand what he or she is getting into. So having not explained it already, the company or the employer is already in breach of the law. Now, she's also saying that this employer is constantly changing the terms of the agreement. It will seem like the person is actually taking advantage of the fact that you may understand English, but because you can't read, he's telling the person that
my version is the right one.
Yes, it's like every day. What I say it is what it is. And unfortunately, that can't be the situation. So, I mean, in such a situation, this person is clearly an illiterate and he has a remedy. He may take certain steps. He should seek a lawyer's advice, provide a document to the lawyer. The lawyer will look at it and take the necessary steps to protect her rights or interests as an employee. I'm very certain there are probably some payments or monies which were also due him or her, but because this employer keeps changing the terms, she's been denied all of these benefits, you know?
The sense I get from this question is that they had negotiated certain terms,
Yeah.
which he or she understood and expected to be what was reflected in the dotted lines he or she signed. It's become clear over time that that person's understanding of what they negotiated is not what the employer is working with, and the employer insists that his or her version is what they signed. So it's still is evidence that all the requirements, the conditions for an illiterate to partake in this kind of arrangement
has not been met.
Yes. There's a gap there, and it can only operate against the employer and not against the interest of this illiterate person within this instance. So like Boachi said, find a lawyer, explain it. There may be some follow-up questions. Were there messages exchanged? Were there voice notes? There could be a lot. Who was there? Were there witnesses? In what language did they even explain it? She says speaks English, but how do you even confirm that that was what was put down and all? So, yeah, find a lawyer.
When signing a contract with a person who does not read or write, whose duty is to find someone to read and explain the document to the person's understanding?
Looking at the question, the person is asking, when signing a contract with someone who cannot read or write English, whose obligation is it to ensure? Looking at the requirements of the law, the person seeking to let the illiterate person sign the contract, or who at a later date will be seeking to enforce the contract against the illiterate person, has to ensure that the terms have been read clearly and correctly to the person, and clearly and correctly in a language the person will understand. So even if the document is in English, but the person understands Tree correctly, the person seeking to enforce the contract or procuring the contract here has to ensure that the illiterate person the document has been explained to them clearly and correctly in the language they can understand. And in fact, to comply with the law, there has to be a jurat by that person or another person showing that the terms have been read over to the person. he appear to understand them, right? So if you are drafting a contract for anybody who is illiterate, or you are seeking to enforce a contract against anybody who is illiterate, make sure that you have explained the terms correctly, or at least at your behest, somebody has explained the terms correctly to the person in a language they can understand the terms there. Then in that regard, you've complied with the law.
I think, what my brother said is more succinct, and the fact is that if you want to enforce the agreement, explain it to the person. Don't take any chance with it.
We haven't considered a situation where both sides are all illiterates.
Well,
and that can happen. And it takes us back to what Kofi said earlier about, look, I would say this, at the risk of looking like I want to hawk or advertise our craft as lawyers.
Get a lawyer.
But you see, get a lawyer.
Get a lawyer.
The reason is you have to look at all the variables, and at the end of the day, your interest has to be protected.
Yeah.
What you really intended has to be there. And if you say that the one who is commissioning the contract should pay, whoever is drafting is looking at that person's interest first, because he's being paid for that. Even in a situation where you are getting a lawyer, most experienced practitioners will not want to be the neutral lawyer in the middle, advising a transaction for two sides, especially where there are two contracting sides with different interests.
I think there's even an ethical issue there.
So each person would have to bring a lawyer, or at least somebody who can read and understand and explain their interests to them in a way that safeguards what their interest is in that setup. So if I am to answer that question in simple terms, it is everybody's responsibility to ensure that people are there to read, write, explain, and stand out for in defense of that person's interest at the time of drafting the contract, way before you sign, and ensure that all the conditions are met, including the jurats, including witnesses, and where necessary or applicable, receipts and reward featured on the documents. And you realize that even with conveyances, lawyers are required to put their stamps and signatures on the document to indicate that they prepared it, to take responsibility for it in case there is any problem.
Yeah. So, basically, please get a lawyer for every document you're preparing.
Still find somebody who can support you, read and understand it to your benefit. It's very crucial.
But then the question is, did the person who have a license draft that document?
Of course, as for the drafting, it's a different conversation. It's about reading and understanding, right?
Yeah, get a lawyer.
This has been a fun conversation. I did not anticipate the conversation to be as exciting, but it's been very insightful. Thank you, gentlemen, for stopping by again. We hope to see you again another time, right? I was joined today by Kofi Owusu Ampiel and Nanabuachi Mensah-Bonsu. My name is Noella Seydu. Our conversation has been on illiterate protection. This has been Law Express. Thanks for staying with us. Till next time, goodbye.